1. Resumption of debate on the Constitution of the Republic of Singapore, Amendment Number 3, Bill, second reading.
Minister Shanmugam.
Thank you, Madam Speaker. I thank Madam Deputy Speaker. I thank the members who have spoken up in support of the bills. Many have, or most have expressed support for the repeal of Section 377A. I will deal with questions raised by members on our approach towards cancel culture, past Section 377A convictions, keeping sex identification in NRICs and passports, Article 156, and one or two other issues. Mr. Zulkarnain asked for any update on the government's plans to deal with cancel culture and whether there will be any consultation and feedback process. My Ministry of Law, is looking at measures to deal with the harm caused by cancel culture, cancel campaigns online. People really ought to be free to stand by their beliefs, express their views with due respect for the feelings of others without fearing being quote-unquote cancelled. Many religious groups and organizations in particular are very concerned about this. Many church groups have spoken with us. Their experience is that when they express their views, they are shouted down and they feel bullied. Children in schools also feel this, and this is not right. I have said that we will try and do something about this. We are studying the matter. We are consulting different groups as part of our review. We want to try and strike a right balance. It's not an easy area to deal with or legislate on. We will give more details when we get a sense of what is doable. Mr. Louis Sung asked whether there are any individuals with existing conviction records under Section 377A and how these records will be dealt with. There are some individuals with convictions under 377A. Most of these cases involved non-consenting victims or acts against minors or sexual acts committed in public. These acts continue to be offenses even after the repeal of or even after any repeal of Section 377A, and we do take a serious view of them. Criminal records for offenses are dealt with under the framework in the Registration of Criminals Act, and within that framework, people can apply to have their convictions spent. Some of these offenses have become automatically spent. Automatic expiry takes place after a period of time for specific offenses and where the criteria are met. Persons who are disqualified from having their convictions automatically spent can apply to the police for the record to be considered spent or rendered spent. But where egregious acts were committed, like non-consensual acts or sexual acts against minors, the records are unlikely to be treated as spent. There are a small number of individuals who were convicted between 1988 and 2007 for consensual private homosexual acts between adults. I've instructed my ministry to consider how the records of these persons can be rendered spent proactively. Mr. Lim Biao Chuan said that he hopes that the government will not allow individuals to remove their registered sex from their NRIC or passport. The short answer is that there is no such plan. Ms. Lim suggested that there is no real need for Articles 156(1) and 2, since the Constitution already vests legislative power in the legislature and the executive authority in the government. Let me explain. It's a fairly basic point. Let's take Section 377A as an example. It's a law made in the exercise of legislative power by Parliament. 377A has been challenged as being in breach of the Constitution. Ms. Lim agrees that 377A could be unconstitutional. And the presence of Article 38 in the Constitution will not help if 377A is in fact unconstitutional. To put it another way, the fact that Parliament can pass laws and that Article 38 gives that power does not automatically mean that all such laws cannot be challenged. They can be challenged, for example, if they are contrary to the Constitution. And Article 156 is structured to give effect to protect laws and policies based on the heterosexual definition of marriage. So Articles 156(1) and 2 have been drafted in to give effect to this principle, to protect the laws and policies based on that definition, and to make it clear that passing laws and having policies based on the current definition of marriage are constitutionally valid. And they give context to Articles 156(3) and 4. We have been advised by AGC that Articles 156(1) and 2 could be relevant if there are questions raised as to whether regulating marriage and so on are constitutionally valid purposes and considerations for action by the legislature and government. Thus, Articles 156(1) and 2 have been enacted to make it clear that the legislature can exercise its legislative power to define, regulate, protect, safeguard, support, foster, and promote marriage. Similarly, the government and public bodies can exercise their executive authority to achieve these ends. Mr. Murali Pillai asked, why is it necessary for Article 156(3) and 4 to exclude the whole of Part 4 instead of just Article 12, instead of just a few articles? Thank you. Let's look at Article 156(3)(a) first. This protects the heterosexual definition of marriage itself from invalidation by Part 4. We need to exclude the whole of Part 4 because we cannot predict what possible arguments might be made against this definition in the future. With 377A, we have seen how the arguments in our courts progress from equal protection under Article 12 to asserting that sexual conduct is a form of liberty protected by Article 9 or a form of expression protected by Article 14. Some of these alternative arguments have been accepted by courts in other countries, and it's possible that additional creative arguments could be made about the heterosexual definition of marriage. For example, could marriage be a form of association that is protected by Article 14? Members may think it is a little outside of the orthodox interpretation today, but can you rule it out? Thus, if we want to properly protect the heterosexual definition of marriage from court challenge, we have to exclude the whole of Part 4. But it's not a carte blanche. What is protected is quite precise. It's the heterosexual definition of marriage. That is because, just as we have been clear about repealing 377A, we took a clear position. We are equally clear, and this government is very clear, that we will protect the heterosexual marriage as a key institution in our society. And that is why the Constitution is being amended. But, let me digress and say, as we say all this, and as we listen to the speeches by MPs on families, let's also not forget, let's also acknowledge that LGBT persons also have and come from families. They have parents, siblings, grandparents, nieces, nephews, aunties, uncles, close friends, and much more. So families are not exclusive to non-LGBT persons. So let's remember and acknowledge that these things are not binary. But back to Article 156. If Parliament tries to enact, say, for example, apartheid marriage laws or impose other outlandish definitions of marriage, those laws would not be protected. Because if you look at Articles 156(3)(b) and 4, the operating provisions, they protect the ability of Parliament and government to make the laws and policies. The protection, the shield is strong, but what is shielded, we have sought to make it quite precise. If the government tries to give benefits to married couples, for example, say with the surname Tan, Article 156 will only protect the part of the policy that relates to married couples. Government will still have to justify why giving benefits to only people with a certain surname is a relevant consideration, and I think lawyers will understand it will probably not be accepted as a relevant consideration. Nor will the government be able to take measures that are absolutely prohibited under Part 4, for example, slavery. If such a measure is taken, the challenge will not be that it is based on the heterosexual definition of marriage or some other basis. It will be on the basis that these measures are not allowed on any basis. So to directly answer Mr. Murali Pillai, no, Article 156 does not enable the government to banish anyone, as the term is conventionally understood today. Why do I say that? Let me give an example. It will be a nice constitutional question if, for example, a same-sex couple were to argue that since Singapore does not recognize same-sex marriages, they had no choice but to emigrate, and that is effectively a banishment, and that this government's policy in not recognizing same-sex marriages is therefore in breach of Article 13, which precludes banishment. Now, so you can see that a careful person will want to think about the different possibilities of arguments and then make sure that the drafting covers the different possibilities. So we do not believe that the government's policies and laws are in breach of Article 13, or for that matter, any other article in the Constitution. But members can see that creative arguments can be made. And so if you want to be clear that you want to protect marriage and keep it within the province of Parliament, then you need to make sure that your drafting is accurate. So that is why we have had to draft Article 156 in the way it has been worded. In the case of executive actions, common law judicial review under administrative law principles will generally still apply. The application of those principles must, however, take Article 156 into account. For example, with Article 156, acting to promote marriage would not be an unlawful purpose or an irrelevant consideration. But otherwise, admin law principles can and will still apply. Ms. Lim and Ms. Hei Ting Ru say that judicial review under Part 4 should be fully available without restriction. Article 156 takes two specific issues out from the court's province and keeps them entirely within the province of the elected branches. One, the heterosexual definition of marriage, and two, the ability of Parliament and government to make laws and policies based on this definition. The government believes that this is necessary for the reasons I have explained. Parliament and the elected government should deal with these questions and try and strike the right balance on these complex and delicate social issues. Ms. Lim's and Ms. Hayes' position would mean that they accept that the courts can strike down the heterosexual definition of marriage, or to curtail the ability of Parliament and government to make laws and policies based on this definition, and for society to live with the consequences after that. This, then, is the choice before the House today, whether we decide to have the certainty that Parliament will decide on issues of marriage, or whether we want to leave this to the courts and live with the potential threat of unconstitutionality and have that change imposed on our society as has happened in other countries. Let me now turn to the Workers' Party's position on 377A. Mr. Pratam Singh, as leader of the opposition, says that the Workers' Party does not take a position on the matter. Thus, as a party, the Workers' Party has no official position. It does not support the repeal of 377A. It doesn't quite oppose either. It also does not support the constitutional amendments to protect marriage. From their speeches, Mr. Singh, Ms. Lim, for example, support the repeal. And while Mr. Singh supports the constitutional amendments, Ms. Lim and Ms. Hei Ting Ru do not support the constitutional amendments. Mr. Dennis Tan and Mr. Gerald Giam are against the repeal but support the constitutional amendments. Mr. Leon Pereira is for the repeal somewhat more enthusiastically than his leader, and as for the constitutional amendments, he takes a divergent position from his chairman, Ms. Lim. So the Workers' Party had a debate among themselves. They debated and discussed, but didn't decide on a party position. And so the question is, if this is how one decides, how will such a team function if they are in charge? Mr. Singh said his lifting the whip on Workers' Party MPs was democratic, so as to allow for a full and honest representation of all views. That explanation is factually untrue. Every MP must know that. So it does no credit to this House to say these things. The Workers' Party MPs could have made all the speeches they made, even with the whip in place. MPs are always entitled to state their honest views. They can agree, they can disagree, they can say what they think. You can express your views, whatever they are, without having to lift the whip. I repeat that. The whip does not and has not prevented MPs from speaking their minds. MPs have always been free to express what their constituents think. The whip is relevant for voting, not speaking, and the whip sets out the party's position. In moving the bills, Minister Masagos and I took pains to lay out both sides of the issue. The PAP MPs speaking on the issue too have reflected the concerns, the fears, and pain of the many individuals they have spoken with. These include views of Singaporeans from different religious groups, LGBT groups, and others. So do not be mistaken. Views on all sides can and have been and must be fully ventilated, and they have been ventilated by PAP MPs. As I said earlier, the whip is imposed to set out the party's position as a whole. In our Westminster parliamentary system, parties must have a view on important questions that come before Parliament. They need to be honest in this House, say what they think is good for Singapore, and be accountable to the electorate for their decisions. The real point is that the WP, as a party, does not want to take a stand on this matter. It does not want to be seen as supporting the repeal. At the same time, it also does not want to be seen as opposing the repeal. That way, it hopes to be all things to all men and not too much of anything to anyone. Members may know the second line was said in respect of a well-known person. In my remarks yesterday, I reminded members there are two reasons for repealing Section 377A. First, it is the right thing to do, because there are no public concerns that justify private consensual sex between men being a crime. Some disagree with that. They think that the law should be retained as a matter of conscience. I mentioned yesterday that I accept that. We understand and respect these views. These are seriously held views by honest, sincere people, including in this House. They have thought about it, have decided that for reasons of conscience and often of personal faith, they cannot agree to the repeal. But I also outlined a second reason to repeal Section 377A, the significant legal risk of it being struck down by the courts if we were to leave 377A alone, and the significant negative and disruptive consequences for Singaporeans and Singapore if that were to happen. That is a policy question, a question that requires us to consider what is in Singapore's interests. From the debate, the following points are clear and are not in question, and the WP does not question them. 1, 377A is at risk of being struck out for being unconstitutional. 2, if 377A is struck out, then there is a further risk that the definition of marriage could be challenged as well. 3, and that then means that there are risks that our housing, education, media content policies, and multiple other policies could all be challenged. No one has questioned these risks in this House. The WP understands this. There are 4 lawyers among them in this House, including Ms. Lim, who has agreed that the legal risks to 377A exist. Given that, then what does the WP as a party propose? If you don't want to repeal 377A and also do not want to support strengthening marriage, which we have proposed, the position with 377A is like a train approaching. The question is whether we have the courage to act or rather dive for cover to protect yourself and leave society to face the train wreck. I emphasized this quite strongly yesterday. Given the risks, we have a responsibility to do our duty as parliamentarians, to take a position, to deal squarely with the problem and not abdicate our duty. To say the party has no position allows the WP MPs to make speeches supporting all sides without having to make a decision and be held responsible for that decision. That's not true democracy. It is better described as wanting to speak without taking responsibility. In the context of our debate, their position will mean that they will leave the decision to the courts and let Singaporeans face the negative consequences, including perpetuating differences and polarizing our society further. If we leave this matter to the courts, because the courts can only make binary decisions, as we have seen happen elsewhere. And if the WP truly believes that these sensitive matters ought to be decided by the court, never mind the consequences, including further dividing us in endless rounds of litigation, then they should be honest and say so in this House. The only reason we can have a decision in Parliament is because the PAP has its whip in place. When you stand up and speak at length about the pain and suffering of the LGBT community, then I think one can ask, why don't you take a clear stand and support the repeal? Or if you believe otherwise, take a stand, oppose the repeal as a party. As I say this, sir, let me tell members, the issue of conscience, which is real, is quite different from the issue of policy. I have focused on the policy issue, and I think it is not too much to ask that a clear stand be taken on policy issues. Let me end by quoting Winston Churchill. They are decided only to be undecided, resolved only to be irresolute. So this government has consulted widely and has come to a position. We believe that our policy offers a way forward. It balances the different views, maintains our social cohesion, keeps us together. The Prime Minister and Deputy Prime Minister Wong have stated clearly that they will maintain this position. On this difficult matter, we will do our duty and take responsibility for holding society together. Thank you, Madam Deputy Speaker.
Mr. Masagos Zulkifli.
Madam Deputy Speaker, I thank members for putting forth their perspectives and reasoning on these very important debates. In this House, members have reflected the complexity of the issue and the diversity of our stakeholders, something a court process will not achieve. Members have shown why Parliament, rather than the courts, is the right forum to debate difficult social issues. We have explained clearly why we must act without delay. Inaction will leave open the significant legal risk that the court will, at some point in the future, rule Section 377A unconstitutional, Parliament has a duty to act. Let me turn to what we all need to do to keep Singapore united after we have debated and then voted on these bills. Many members touched on these in your speeches. Some have voiced the concern of Singapore going down a slippery slope after the repeal. Some touch on support for families with single parents. Others ask about the posture in educational institutions and express concerns on religious freedom. Mr. Alec Yam, Mr. Sharil, and Mr. Abdul Samad have asked for assurance that the repeal would not result in a change in social norms. Mr. Derek Goh asked about the use of surveys and engagements. It is indeed the intention of the government that there should not be a change in social norms following the repeal. This is precisely what Article 156 is intended to achieve. I explained in my speech yesterday that many different practices and policies that support society's notion of children within a marriage between a man and a woman. On surveys, while they can help facilitate conversations and potentially reduce discrimination, we recognize that a single or a series of questions would not fully capture such a complex and emotive matter. It also depends on the survey's sampling method, whether it is representative, and when it was conducted. We have engaged extensively on this matter. There are ongoing efforts to facilitate conversations and civil dialogue. Mr. Pritam Singh, Mr. Mark Che, Mr. Louis Ng said that there should be support for other families such as single unwed parents. My opening speech explained our approach. We make a distinction between incentives and supports. Benefits intended to support a child's development and caregiving are given to children of single unwed parents and of married parents equally. These include healthcare and education subsidies, the government's First Step grants, and co-matching of the child development account, as well as the government-paid maternity leave to unwed working mothers to care for their infants. Let me now turn to educational institutions. Ms. Janet Ang and Mr. Fahmi have asked about sexuality education in public and private schools and the madrasas. Dr. Tan Yaswam said students should be taught based on evidence. Mr. Henry Quek commented that school leaders should take a clear, objective stance. Mr. Mark Che asked how we prepare students to be more understanding and emphatic. Mr. Lim Biao Chuan also asked about international schools that compel staff or students to participate in gay community projects, even if they do not subscribe to the same lifestyle. I explained in my opening speech that our education policies and curriculum remain anchored on Singapore's prevailing family values and social norms, which most Singaporeans want to uphold. These include the family as the cornerstone of our social fabric and marriage between a man and a woman. In our schools, all students learn and practice values such as mutual understanding, respect, and empathy for everyone. They will also understand that issues can have multiple perspectives and are taught to listen to each other's points of views, understand the perspective of others, and learn to interact and engage respectfully with each other, even if their views differ. The sexuality education curriculum in MOE schools respects the primary role of parents and reflects the national posture on the heterosexual family as a basic unit of society. The curriculum remains secular and based on research and evidence. It is focused on age appropriateness and the developmental needs of the child when touching on topics such as homosexuality. In madrasas, sexuality education is part of the education curriculum and included in specially curated programs. madrasas are also equipped with trained asatiza and teachers to address sexuality issues. Counselors are available should students need further advice and support. MUIS is in regular consultation and collaboration with the madrasa to further enhance the sexuality education curriculum for students. Teachers will also be equipped and updated on the current discourse on the matter to advise and guide students on matters related to sexuality according to the teachings and traditions of the religion. For international schools, MOE does not regulate the curriculum. That said, as the schools operate in Singapore, they should respect our social norms and values. They must also be careful not to cross the line into advocacy on issues in Singapore that could be socially divisive, such as how sexual orientation are handled in laws and public policy. These are matters for Singaporeans to discuss and decide. Mr. Louis Ng asked how LGBT students struggling with family and mental health issues are supported. Mr. Zulkarnain also asked how teachers and educators are supported. Our schools have a system of support for students with issues concerning their well-being, including on sexuality. Teachers will listen to students objectively to facilitate support and not discount, disregard, or judge their views. They assure confidentiality, but explain to students that the disclosed information has to be shared with the appropriate key school personnel to assist students in managing their concerns. Teachers also consult the school leader and lead school counselor who will further manage these cases with the school counselor providing targeted support for the students' concerns. Where required, schools will, with parents' consent, refer students to professionals and relevant authorities to provide counseling support and appropriate intervention. MOE's focus is on the students' well-being. Students must remain a common and safe space for all students, regardless of their background. We have a duty to care for every student. For students with sexuality issues, our focus is likewise to provide them with a conducive learning environment and the necessary support to ensure their overall well-being. As sexuality issues are complex, schools work with these students and their families sensitively. Mr. Zulkarnain asked where families can seek help. Family service centers offer family counseling and can also assist if family relations are strained because one of them has sexuality concerns. Lastly, members, Mr. Christopher D'Souza, Mr. Zulkarnain, Mr. Fahmi, and Mr. Lim Bao Chan, Mr. Daryl David, Ms. Janet Ang, and Mr. Alex Yam have spoken about religious freedom. I would like to make clear the government's position. First, Article 156 will provide further protection for the definition of marriage as between a man and a woman. There are no plans to change this definition to include same-sex marriages. Religious leaders or any licensed solemnizer for that matter cannot solemnize a same-sex couple. This is against the law. Second, religious freedom is protected in Article 15 of the Constitution. Every person has the right to profess, propagate, and practice his or her own religion, subject to public order, health, and morality. Every religious group has the right to manage its own religious affairs. One can still preach on the pulpit their beliefs about homosexuality or family, even if others might disagree. But no one should incite violence or hate towards others. This is against the law, and it's not the society we want to become. This is regardless of whether the comments are made in public, online, or in your private space. Religious organizations, as owners of their premises at places of worship, have the discretion to refuse same-sex solemnizations or weddings to be held on their premises. There is no law which prohibits them from treating same-sex couples differently from opposite-sex couples when exercising such rights. Religious organizations may support those who are struggling or have issues with their sexuality, including through prayers and counseling, as long as consent is obtained and criminal thresholds of harm are not crossed. Third, in exercising religious freedom, we must understand that we are also members of a plural society. We must graciously accommodate those who have different values from us. Gay people are members of our society and have access to the same opportunities and social support as other Singaporeans. Social service agencies provide secular services to the community. Some SSAs are set up by or affiliated to religious organizations. All SSAs, regardless of their religious affiliations, serve all clients, including gay persons. Social service professionals are continually trained to be sensitive to the diverse needs of their clients. Fourth, on employment, workplace, and businesses. We do not tolerate discrimination at the workplace. Employees are protected against discrimination under the tripartite guidelines for fair employment practices. These guidelines require employers to make employment decisions based on merit and not factors irrelevant to the job. For religious organizations, understandably, the potential employee's religion and values would be a relevant consideration for certain roles. Mr. Derek Goh inquired about staff benefits offered by companies to gay couples. The government generally does not interfere in how a private business operates. However, private businesses must respect that their own staff have a right to their personal beliefs. They also cannot cross the line into advocacy on issues in Singapore that are socially divisive, which includes issues on homosexuality. These are matters only for Singaporeans to discuss and decide. At our workplaces, employees should not feel compelled to support causes or participate in activities that do not align with their beliefs. The TGFEP is clear that an employee's support or non-support of causes is not relevant to job performance, cannot be used in employment decisions and performance evaluation. Lastly, we should keep the marketplace free from the polarizing contestation of values. In a free and open economy, with abundance of choice, businesses can decide what events are allowed on their premises. However, while businesses make their own commercial judgments with regard to their prospective customers, they should do so in a sensitive and respectful manner. Nonetheless, I urge everyone not to use commerce as a platform to display the conviction of their beliefs. In the spirit of mutual respect, I hope businesses and prospective customers can strive to be gracious and adopt the approach of live and let live. Madam Deputy, Mr. Speaker, sir, for complex issues such as these, we must exercise leadership to make difficult decisions that is best for our society, even if it does not satisfy everyone's wishes. We are a secular government, and while each of us as individuals may have our religious convictions, we take care to ensure that when we make decisions for the whole country, we apply secular, universal values and not individual religious beliefs. Mr. Dennis Tan, Mr. Gerald Giam, and Mr. Faisal Manap indicated that they will not support the repeal because of their religious values. Yet they do not offer any solution on how we can keep society united and cohesive. If Section 377A is found to be unconstitutional, is their solution to accept a decision by the courts? What would be the implications? If so, why not vote for the repeal now? Ms. Hazel Phua says PSP wants the definition of marriage to be decided by national referendum rather than by Parliament. The government has explained why we are not proposing to hold referendum on this issue, but let me explain again. Our Constitution sets a very high bar for the holding of referenda. A referendum is required when sovereignty or the command of our armed forces and police is at stake. We have only one referendum in our history on merger with Malaysia. We should be very careful about elevating any matter to this level, saying it is equivalent to an issue on sovereignty. It's the duty of elected MPs to consult, to discuss, and to come to a decision, even and perhaps especially for difficult and polarizing social issues. The PSP says that we should not allow Parliament to decide, but instead let the definition of marriage be decided by national referendum. This might seem seductive, but let's call it what it is. It's an attempt to avoid taking a position as parliamentarians, as elected representatives of the people. Even if a referendum is held, which side will the PSP be on? Will the PSP try to bring people together or stay silent on where it stands on heterosexual marriage, as it's doing in this debate? Also, will the referendum settle this issue once and for all? May I remind members and the PSP what happened in the UK with Brexit? Both sides campaigned vigorously and bitterly. It created an entrenched, polarized identities. Brexit was eventually approved in a referendum with the slimmest of margins, and people continued to campaign for a second referendum. In the process, the credibility of the British government was severely damaged. Indeed, it has yet to recover. Despite being government, the Tories were split on Brexit. The leadership, rather than uniting around a single position, allowed their MPs and even their ministers to take different views. A government unable to act cannot govern. Let us not look for politically easy options and cite referendum as an easy solution, just so that a decision does not have to be made in Parliament. In any case, even if the PSP wants a referendum, does it or does it not support the constitutional amendments? They seem to be against it. It then leaves the courts to decide on heterosexual marriage. I've explained why this is not ideal. In any case, PSP seems to be against the constitutional amendments. I've explained why that is not good for Singapore. Mr. Speaker, governing requires us to bring people with different perspectives together, to ensure that various segments do not push for a maximalist position which would impinge on others, and pave the way forward. Especially, we should not adopt positions just because it coincides with our own religious beliefs. Indeed, everyone in Singapore cannot expect their maximalist position to be realized because Singapore is a vastly diverse society. Singapore has progressed because everyone understands this and have been accommodating of each other. This applies to governance. To be able to faithfully discharge our duties as leaders, we cannot make decisions that affect our fellow citizens based on personal religious beliefs. Instead, I hope we understand the principles of our religions in making decisions that affect others. That's what the Malay Muslim leaders we engaged were able to do after numerous engagements. They went beyond their own perspectives and assessed what is good for the community, Singapore, and Singaporeans. They accepted why these changes need to be made. I hope all members of this House can do so too and support the repeal of Section 377A together with the proposed amendments to the Constitution. Let me conclude. As a society, we cannot lose sight of mutual respect when we engage with one another and must endeavor to listen to those who disagree with us. We must not destroy their social or economic standing. We should not denigrate others. This applies to all sides in every debate. We should consistently exercise responsibility, restraint, and sensitivity to one another, both online and in person. The work of staying united as one Singapore is what lies ahead of us, even as the debate on these two bills conclude. Mr. Speaker, this debate proves that this House is indeed the right forum for issues and policies that are complex and require political judgment. It's an example of Parliament stepping up to do its duty. It's a responsible government that has balanced the views expressed by members and stakeholders and has shown the viable way forward. We did not deflect the matter to the court, nor kick the can down the road. This is the strength of our system in Singapore, when each branch, the legislature, executive, and judiciary, does its part to its fullest and does it well, and does what is right for Singapore and Singaporeans. We have had a robust debate with the passing of the two bills, the repeal of Section 377A and the introduction of the constitutional amendment. We have created space for society to deliberate on social issues within the political process and not through a legal route which is zero-sum in nature. It's time to come together and move forward. Preserve the peace and stability that our society has fought hard for and forge ahead. United, not divided, so that we can achieve progress as a nation for many more years to come. Thank you.
Mr. Pritam Singh.
Thank you, Mr. Speaker. I think the Minister, I refer to Minister Shanmugam, has mischaracterized my speech somewhat. What I said was specific to the party position in 2019, and here there was a context. The party position, as I mentioned, was varied and divided, with no consensus as to whether 377A should be repealed, and as I said, somewhat similar to Singapore society. I lifted the whip and did not fetter the voting rights of MPs. I did not say speaking rights. I did not fetter the voting rights of MPs. This is consistent with the party position. What has been the result arising from this debate? 6 for a repeal of 377A, 3 against for reasons of conscience. The party position has now been established by way of a majority in Parliament. On the Constitution, 7-4, 2 abstentions for the reasons the members mentioned. All the Workers' Party MPs, apart from Mr. Faisal Manap, who is down with COVID-19, put their personal positions on the record. And in my view, they behaved like a loyal opposition, not loyal to the PAP, but loyal to Singaporeans, knowing the position of Singaporeans outside of this House. I have 2 clarifications for the Minister, the Speaker. The first, my question pertains to an understanding of how and why the PAP chooses to lift the whip for some bills and not others. And I raise this because the Minister raised it in his closing address. DPM Wong announced that the PAP did not lift the whip for this debate because 377A is a matter of public policy. The Prime Minister in his National Day address this year said that not everyone is equally accepting of homosexuality, and there were considerable reservations within certain religious groups. Now, for the Human Organ Transplant Bill of 2009, the PAP lifted the whip so that MPs could vote based on their religious and ethical beliefs. The first generation of PAP leaders under Lee Kuan Yew did the same with the Abortion Bill of 1969, where Mr. Lee Kuan Yew himself rose to deliver a speech, but was absent when it came to voting. If I follow Minister's reasoning, would it be correct to say Mr. Lee Kuan Yew was abdicating his responsibilities? Now, there would be compelling reasons to suggest that for both these bills, public policy could have been deployed as a reason not to lift the whip. But the PAP lifted it anyway. Can the Minister please clarify the consistency or lack of consistency with regard to lifting the whip? My second question pertains to implications of the constitutional amendments for the LGBTQ+ community in the political context. With these amendments, the effect would be that the courts are not the correct forum to determine questions of housing policy and same-sex marriage, for example. At the 2011 general elections some 11 years ago, the sexual orientation of an opposition candidate came into the spotlight, with the PAP asking the Singapore Democratic Party to, I quote, "come out of the closet," unquote. And the PAP statement on this issue pursued an innuendo that made an allusion to pedophilia. In view of the speeches made by PAP MPs over the last 2 days and the call for any change on the definition of marriage to be a political question, can I confirm the PAP's position with regard to LGBTQ+ candidates standing in general elections? Thank you.
Thank you, Mr. Speaker, sir. Now, Mr. Singh mentioned democracy. He said that in the pursuit of democracy, he will lift the whip. If he now says that's not so, then he can state that for the record. He said, we are more democratic, we lift the whip, and I just wanted to point out, let us just be accurate. People can speak their minds even with the whip imposed. And when Mr. Singh says the whip will not be imposed on his MPs, he is referring to voting positions. He is referring to a party position that when he came into chambers here yesterday, the party did not have a position. That is what we are talking about. And his MP spoke on both sides. Party did not have a position. It's not a question of totaling up the numbers at the end of the day. It's a question of coming up front and saying, this is our position as a party, even though individuals have their different views and they will speak about them. That is the point I was addressing. Now, when will a whip be lifted and when will a whip not be lifted? I made it clear in this case why is the whip being imposed. It is because it is a policy question with serious consequences for Singaporeans. If we do not repeal Section 377A, then we are saying we will not do what we have to do, and we will pass on the buck to the courts. That's an abdication of responsibility as parliamentarians. In such a situation, lifting the whip is not acceptable for the PAP because societal interests are at stake. But where it's purely matters of conscience, and you don't quite see such a significant issue for society as a whole, where the very institution of marriage and all your housing policies and your education policies and your rules on the structure and basic content of society can change overnight, and where societies get rent asunder by cultural wars. Those are the risks we are talking about. And do we duck and say, well, we don't have a position? So you're leaving it to the courts. Abortion is quite different in that it was a matter of individual conscience, at least at that point in time. I think today the issue is well settled, in Singapore at least, unlike in some other countries. But at that time, it was a matter that raised very serious personal concerns. I mean, people would know the arguments in Ireland much more recently. So I wasn't in the House at that point in time, and I don't think we should draw conclusions from the fact that one or another member was present or was not present. But I would be careful if I were Mr. Singh to bring Mr. Lee Kuan Yew into this and suggest that he somehow acted dishonorably. Now, if Mr. Singh can remind me on your second question.
It was about the LGBTQ question vis-a-vis whether they would, the PAP's position as to whether the LGBTQ community would not be victim of some personal attacks.
I think Mr. Singh mentioned pedophilia. Again, I don't recall the facts, so I can only answer in hypotheticals. I think if a pedophile was standing for elections, I'm surprised Mr. Singh would advocate that cause. Thank you, sir.
Mr. Pritam Singh.
Mr. Speaker, let me take up the last point. Before that, sorry, the point of abdication and suggesting that I'm saying Mr. Lee Kuan Yew was dishonorable. I never used those words. I think I made the point in the context of the question that I put to Minister. On the issue of pedophilia, let me share the specific statement that the PAP made, which led me to make that point. This was the statement that was released by the PAP. What is his agenda? A video has been posted on the internet showing Vincent Vijay Singha participating at a forum which discussed the promotion of the gay cause in Singapore. I don't think there's a problem with that statement. And thereafter it says, the discussion at the forum also touched on sex with boys and whether the age of consent for boys should be 14 years of age. The innuendo, I think, is clear. In the video, Mr. Vijay Singha was introduced as being from the SDP. In addition to other comments, Vijay Singha stated, I think the gay community has to rally ourselves. Perhaps one outcome of today's forum would be, for those of us who are interested, to come together to further consider how we can address the 377 issue, as well as further rights issues in relation to gays and lesbians. Now, I don't have any issue with the PAP coming up and saying, look, what is the political agenda of a candidate? But what is the relevance of that point on sex with boys? If not to cast aspersions on the candidate himself and to suggest that, did he make that point? Was this a forum where this was the only issue that was discussed? So that was intentionally included. That's my view of the statement.
Mr. Speaker, sir, I hope we don't have to go into an extended discussion on this. Mr. Singh started out the second question by saying that pedophilia was talked about. Now, let me make it clear to him. If there is a candidate who is standing for elections, whether for the PAP, and I hope the PAP will never field such a candidate, or for the Workers' Party or SDP, and if there is a suggestion of pedophilia, I will certainly speak about it. And I'm sure all right-thinking Singaporeans will speak about it and will say it is not acceptable. So I don't quite know the precise context, but as I said in my speech, sexual offenses against minors continue to remain serious offenses, and we take a very serious view. And I hope Mr. Singh is not suggesting that pedophiles stand for elections and we do not need to talk about it. As to whether there are broader innuendos, I think let's get to the point, Mr. Singh. As the Workers' Party trooped into Parliament yesterday, there was one point, and that point is Mr. Singh, sir, as leader of the opposition, was not prepared for his party to take a position. That is what we are talking about, not about an election held in 2011. We are talking about 2022, what is our position on 377A, and whether we come here prepared to take a position or we are abdicating. I think I've made my points. We leave it to Singaporeans to judge.
Mr. Singh.
Likewise, Mr. Speaker, I think I've made my point with regard to what Minister has said, but the issue wasn't about pedophilia, and I agree with him. I don't think anybody in Singapore would be thrilled to have a pedophilia as a person who is a pedophiliac standing for elections. But the question I asked was, what is the PAP's position with regard to LGBTQ plus candidates standing in general elections? I don't think a question has been answered.
It appears to me that, as usual, Mr. Singh wants to move the goalposts and start an entirely new debate about who can and who will stand for elections. I'm not the Prime Minister or the Secretary General of the party, but my personal view is that anyone who is not a criminal and who is of good character and of sound mind and who can work for the residents ought to be able to stand for elections. In all of this, in a democracy, it also depends on how people are perceived and accepted in society. All of these are relevant considerations. One has got to look at individual candidates. But Mr. Singh started out by talking about pedophilia. I'm sure the records Hansard will show that. And that is why I answered, because I was shocked that he would even ask that question. Thank you.
Mr. Singh.
Indeed, Mr. Speaker, the record will show what the context was with regard to that point on pedophilia. But I accept a Minister's reply to my second question. Thank you, Mr. Speaker.
Any other questions, clarifications? Ms. Hazelpour?
Thank you, Mr. Speaker. I wish to respond to Mr. Massago's comment earlier on PSP's position. I wish to clarify that our position on wanting the definition of marriage to be determined via a national referendum instead of Parliament is not a convenient way to avoid difficult decisions. A case in point would be the fact that we do have a position on 377A, which is also a difficult one. We are aware of the government's position on what the criteria for holding a referendum is, just that we have a slightly different view on what are the issues that should go for a referendum. In this particular case, on the issue of the definition of marriage, we feel that this is an issue that is important to many Singaporeans, and there is a high level of interest from the public to have a say in this matter. And since it is an area that does not require any specialized knowledge, which makes it unsuitable for participation from members of the public, we feel that, and actually marriage, as many members have pointed out, is a matter of social norm. We feel that this is an area that is suitable for the public to participate. Thank you.
I thank the member for the clarification, but I think the most important question is not the referendum, is what is PSP's position on the constitutional amendment? Are they for or against? And therefore, when the referendum, if held, are they for or against?
Okay, as far as the vote for the constitutional amendment is concerned, we will be voting no because of what I explained earlier, that we would like the definition of marriage to be via referendum rather than by through Parliament.
Finally, that's come out in the open. So we know that they're going to support the repeal of 73A. 377A, sorry. Repeal of 377A, but they will not support that the constitution, the amendment to the constitution be made, which means that while now there will be no further challenges to 377A because it doesn't exist, there will now be new challenges that will be put up in court on constitutional grounds that other institutions like marriage and families, important to many Singaporeans, will now stand before the court, and then we're back to square one again. We have to reactively again come to make a decision or wait for the court to make that decision.
We will support a constitutional amendment if it says that the definition of marriage is to be determined via national referendum.
Then we'll wait for the train to crash on us.
Mr. Willem.
Thank you, Speaker. I wish to make 4 points, if I may. 3 are clarifications for the Home Affairs Minister, and 1 is a clarification on my position on the Constitution Amendment Bill. So let me go to the clarifications for Minister for Home Affairs. Okay, yesterday during his call it second reading speech, he cited many court challenges to the constitutionality of Section 377A. We are all aware of them. But I don't believe any of the ministers cited any court challenges to the heterosexual definition of marriage. So I'd like to ask the government whether there has been any court challenge to the heterosexual definition of marriage. And to that extent, would he not agree with me that his analogy of the oncoming train applies to 377A but does not quite apply to the heterosexual definition of marriage? Second clarification. Earlier, he mentioned that the government does not believe that their policies violate the Constitution. So I'd like to ask him, without Article 156 being enacted, is the government not confident that it can convince a court that marriage based on a heterosexual definition is based on reasonable criteria? It serves the purpose of promoting procreation within a family unit under AMLA, under Women's Charter, and therefore, the government is on much stronger footing on this, the constitutionality of the heterosexual definition of marriage compared to 377A. That's my belief anyway. The third clarification is I'd like to ask him to confirm that he accepts that the courts have a constitutional role to ensure that Parliament's laws and government actions do conform with the Constitution. I'd like his confirmation on that. And lastly, sir, my clarification. For the Constitutional Amendment Bill, I did say that I am not opposing the bill, but I'm abstaining. And the reason I'm abstaining is that I am concerned about the role of the courts as having judicial oversight over the legality of government actions and Parliament. I'm concerned that should be protected. So I, for one, value it, and that is why I'm abstaining.
Clarify or repeat the third clarification, please. I didn't quite get that. The third clarification.
The third clarification is I'd like our Minister to confirm whether he accepts that the courts have a constitutional role to ensure that government actions as well as Parliament's laws do conform to the Constitution.
Yes. Okay, so 3 questions. One, whether I agree that while there is a more immediate risk on 377A, that those concerns don't quite apply to the definition, the current definition of marriage. No, I don't quite agree. I think what we can see and what we need to take reference from is what has happened elsewhere. So we agree that there is a significant risk to 377A. I think there all of us agree. What is the government's concern about the current definition of marriage? You look at what's happened in India. The courts first said that their version of their 377 was not unconstitutional, and then within a few years they said Well, it is unconstitutional. And now, earlier this year, they have said the definition of marriage should be broader than a pure heterosexual marriage. It's a similar system and similar broad common law principles. One can say and one can discern that there are different approaches that the Singapore courts take vis-a-vis the Indian courts. But I think if you were to look at it as a lawyer, legal analysis, and particularly if you are charged with a heavy responsibility to make sure that Singapore is looked after properly and that you care for Singapore and that your concern is for the well-being of Singaporeans, then you will not take these risks. You will think them through, whether it is immediate or perhaps it is in the midterm. If you think that there is a risk, then our duty is to go out there, explain the risks, and then say how we would seek to put the laws in place to protect society, protect marriage, protect the institution of marriage and the structure of marriage, so that our society, successful as it has been, can continue to be successful, and so that the fundamental values of Singaporeans can be protected. It's not a game. You don't take chances. You don't take fine legal analysis. Fine legal analysis is necessary to identify whether there is a risk. Once you identify there is a risk, you then don't go and take chances. So if one were to ask, is the risk to the heterosexual definition of marriage less than the risk to Section 377A? The answer is yes. But that does not lead to, well, we don't have to do anything about it. If there is a risk to something as fundamental as marriage, you act, or at least this government acts. Now, second, do I not believe that the government can convince the court that marriage, that providing for a heterosexual definition of marriage, we can tell the court it's reasonable to say it should be between a man and a woman? Well, you've seen the arguments elsewhere. You've seen the social policy changes in the United Kingdom from which many of our laws come. Of course, there the laws have been changed through Parliament, but there are many countries where the laws have been changed through the courts. And I, for one, while I believe that our courts have always taken the approach, there are three great branches of the state, as I said yesterday: the courts, the judiciary, Parliament, and the executive. And the system has worked well because each has respected the sphere of the other, and our judiciary is independent. If I were asked, I would say there is a reasonably good likelihood that we will be able to persuade the court today that there is a basis for making a distinction between same-sex marriages and heterosexual marriages, and that the current definition of marriage in the Women's Charter should be maintained. But if I were asked a different question, is there a risk that it could be struck out? I think it would be either a stupid lawyer or a foolish lawyer who will say there is no risk. And if you accept that there is a risk, then what do you do? What do we do as parliamentarians? I think the answer is clear. Third, do I accept that the courts have a constitutional role? Of course, I accept that. But I think if the question goes towards why do we then say that the courts should not look at the definition of marriage, I think I've given a very extensive answer. What should count as marriage should be decided here. The courts can only make binary decisions. We should discuss it, we should decide it, and we should take into account what society is ready for and what society needs and what strengthens society. And even if we take a view which is different from the majority view, then it's our duty to go and convince society as to why we are taking that view. We can do all of those things. The courts cannot do those things. That is why we have decided there is this risk that the definition of marriage could be challenged. And we have decided that's a matter for Parliament. We are not providing for a supermajority, so any elected government, by a simple majority, can decide on what a marriage ought to be like. That is democracy. That's how democracy ought to work. And no court can do what we did yesterday and today, which is to consider repealing 377A, but at the same time, strengthening the institution of marriage and explaining the reasons, having it fully discussed, going out to the public and explaining. That is what's necessary, and that we believe that a future discussion would require these sorts of discussions, and it may require changes to more than one piece of legislation. How does the court do that? They will decide on the question presented to them and strike out if they think it should be struck out. Where does that leave society? So this is not a case of, oh, are we avoiding the supervisory jurisdiction of the courts? It's been explained. And I believe majority of Singaporeans, the overwhelming majority of Singaporeans, support us on this constitutional amendment.
Constitution of the Republic of Singapore Amendment Number 3 Bill. Item 2, Penal Code Amendment Bill, second reading.
Minister for Home Affairs.
Mr. Speaker, sir, I beg to move that the bill be now read a second time, and I suppose I should read out yesterday's speech. Sir, the Penal Code Amendment Bill will repeal Section 377A of the Penal Code. As members know, it criminalizes acts of gross indecency between males, whether in public or private. And this bill is linked to the previous bill in our order paper, the Constitution of the Republic of Singapore Amendment Bill, Amendment Number 3 Bill. In the debate we have just had on the Constitution Amendment Bill, I have explained the reasons for repealing 377A. Members have already raised their questions and expressed their views on both bills during the earlier debate, although they are still welcome to do so now if there are any additional questions or views. And before I sit down, sir, I've gotten the transcript of what Mr. Singh said yesterday, and I think I should read it and put it on record. He said, and I quote, "The People's Action Party has announced that it is not lifting the whip for this debate. Given the very public opinion on the impending repeal of Section 377A, there is a risk that the democratic value of Parliament could be diluted if the views of Singaporeans on this subject are not adequately ventilated in the House." That's the point I was responding to, and that's simply untrue. It's inaccurate, and it does not do this House any credit, because you are entitled to ventilate your views. We have always been ventilating our views, and it should not be thought of in public that if the whip is imposed, you cannot ventilate your views. Mr. Singh also explained that the Workers' Party will be lifting the whip, and he wasn't talking about some years ago, he was talking about this debate. If needed, I can read out other paragraphs, but I think I'm just reading out what he said. Thank you, sir.
Mr. Singh.
Mr. Speaker, that is an accurate rendition of what I said. But immediately after that also, I said not lifting the whip would deny Workers' Party MPs not in favor of a repeal of 377A the opportunity to vote freely, and in doing so to also represent Singaporeans who see this issue as a matter of deep religious belief and conscience. But the minister is not wrong when he says, even though the whip is not lifted, it's entirely true that members can speak freely. I don't dispute that, Minister.
Thank you, Mr. Speaker. So I thank the leader for that clarification. And so I stand by everything I've said earlier, which is based on an accurate understanding of what Mr. Singh had said. And so I think I'm not seeing many people wanting to speak, but we will.
Any more clarifications, comments? No?
I beg to move, sir.